Now calling case number 25F55774. This is the people of the state of Michigan versus India Charisma Amaris Tootle. Appearances for the record, please.
Yes, Your Honor. Good morning. Katie Rusmirsky for the people.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender. I'm requesting appointment to represent Ms. Tootle.
Thank you. Did you want to address the plea?
Yes, Your Honor. I have reviewed the complaint with Ms. Tootle, so we would waive the formal reading and stand mute at this time.
Okay, thank you. Ms. Tootle, you have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. You are not required to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that last part doesn't apply to you, don't worry about it. Do you have any questions about your rights?
No, Your Honor.
Okay, thank you. Because this charge is considered a felony, you have the right in this case to a preliminary examination that must be scheduled within the next 21 days. A preliminary examination is a hearing held before a judge where the prosecution must present sufficient testimony and evidence to establish that probable cause exists to believe that a crime was committed and that probable cause exists to believe that you committed the crime. So it's a hearing to determine whether or not the case is strong enough to go to trial. If the court determines that it is strong enough, then the case will be bound over, that is transferred to the circuit court, which is where your actual trial will take place. Any questions about that?
No.
Okay. Prior to the preliminary examination, the court will schedule a probable cause conference. That is a hearing and an opportunity for your attorney to meet with the prosecution to discuss your case for any potential issues or resolutions. Your probable cause conference will be November 20th, 2025. That will be at 9 in the morning in person at the 14A1 District Court in Courtroom C. 14A1 is the courthouse that's located basically above where you are right now at the jail. All right. Okay. Lastly, the court will set bond. Bond is set in all cases, and the purpose is two things. One is to ensure your appearance at future court dates, and the other is for the protection of the public. So do the attorneys want to address bond, please?
Your Honor, is the court in receipt of the people's request on the bond form?
Yes.
I think that request from a different APA was for a $30,000 cash surety. I certainly understand that that is perhaps a larger request than maybe we frequently see in retail fraud cases. I will indicate that the justification for that on the form tracks with me. There's a prior retail fraud first conviction. In this particular incident, there was over $2,000 worth of goods that were stolen. And in addition, it appears that the defendant here is a suspect in 6 other Lululemon retail fraud investigations. So that's the basis for the request, Your Honor, and I don't really feel I have anything to add to that unless the court has any questions.
Thank you. Attorney Yagi?
Thank you. We are requesting a personal bond at this time for the following reasons. So first of all, Ms. Tootle is working and in school. She works at the Tropical Smoothie, and she's also in school studying culinary arts. She is relied upon to help support her family. Also, she has a mom who has health issues and surgery coming up, and a little sister who rely on her to help pay their bills. I understand the people's representation to the court. However, at this time, I only saw, let me see here. I don't believe, I only saw one hold for a traffic case for Ms. Tootle. So I think it's a little premature for the people to say she has all these other allegations against her if they aren't pending charges. At this time, I'm not aware of the pending charges, and I'm going to double check her iChat to see. I didn't see. Let me see here. Oh, it looks like there's a pending charge that I do see out of Novi, I believe. but all of that is to say, I don't believe, given that this allegation is from June, and I think that alone should be reason for the court to grant Ms. Tootle a personal bond, as there's been no indication that she's fled since then. She's obviously was arrested here in the county. Her family's here in the county. In terms of risk to the community, I think there's no reason to for the court to depart from the standard conditions, which would be no going to any Lululemon store. And there's no reason to believe that Ms. Tootle would violate that bond condition. As we discussed, she understands she's facing very serious consequences if she even goes near a Lululemon store, if she is able to be released in bond in this case. So I think that would provide the adequate assurance to protect the Lululemon stores in these matters. So with that, we would request a personal bond with the standard conditions.
All right, Ms. Tootle, the court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. You are not to leave the state of Michigan without the court's permission. You are not to go to any Lululemon location anywhere. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court, the next one in this matter being that probable cause conference on November 20th. Any questions about the bond conditions?
No, Your Honor.
These conditions will be entered into the Law Enforcement Information Network. They will be readily accessible to any police officers that you may come into contact with. If they have probable cause to believe that you have violated one of these conditions, they can arrest you on the spot, and you'll be held for a bond violation hearing date in front of a judge who may revoke your bond and set a new, more restrictive one. At this time, the court is going to set a $30,000 personal recognizance bond. So what that means is you are not posting anything to get out today. Basically, you are promising to appear for your next court date and to abide by all of the bond conditions. If you fail to appear or violate any bond conditions, your bond, well, a bench warrant can issue for your arrest. Your bond can be revoked entirely. At a minimum, it's going to start at the people's request for $30,000. Any questions about anything I just said?
No, Your Honor.
Okay, thank you. Anything else from the council?
No, thank you, Judge.
No, thank you, Your Honor.
Thank you. Magistrate Attorney Raspersky, but thank you for the promotion. All right. You are free to go to the door and tell the jail that you're finished. Your hearing is.
Okay, thank you. Have a good day.
Hello, can I have your name, please?
Chantrell Stevens.
Okay, say that again.
Chantrell Stevens.
Stevens. I do not have you on my. Yeah, we don't have the paperwork for you. You're not being seen today.
Your Honor, if I could at least indicate to the court, I reviewed that case and denied authorizing charges. So I'm, yes, surprised that that has not been processed to that end yet.
Can you have the court officer or the go to the door and get one of the officers, please?
Excuse me. The judge wants you. He's coming, man.
Good morning, Your Honor.
Hi, so I'm being told that the charges for Chantrell Stevens were denied,
Okay.
so
All right.
being processed so she can be released.
Okay.
Okay. Thank you.
Sounds good. Thank you.
Thank you so much, Your Honor.
Thank you all. Thank you.
Y'all have a good day.
Thanks, Your
Hello, can I have your name, please?
Andre Mitchell.
Thank you. Now calling case number 20FB1693. This is the people of the state of Michigan versus Kim Calandra Mitchell. Can I have appearances for the record, please?
Yes, Your Honor. Katie Rosmersky for the people.
And Laura Yagi, Assistant Public Defender, requesting appointment with and on behalf of Ms. Mitchell.
Great, thank you. And Ms. Yagi, or Attorney Yagi, excuse me, did you want to address the plea?
Yes, thank you. We have reviewed the charge, so we would waive formal reading and stand mute at this time.
Ms. Mitchell, you have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. You are not required to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that last part doesn't apply to you, don't worry about it. Do you have any questions about your rights?
No.
Because this charge is considered a felony, you have the right in this case to a preliminary examination that must be scheduled within the next 21 days. A preliminary examination is a hearing held before a judge where the prosecution must present sufficient testimony and evidence to establish that probable cause exists to believe that a crime has been committed and that probable cause exists to believe that you committed the crime. Basically, it's a hearing to determine whether or not the case is strong enough to go to trial. If the court determines that the case is strong enough, then it will be bound over, that is transferred to the circuit court, which is where your actual trial will take place. Excuse me. Do you have any questions about any of that?
No.
Okay. Prior to the preliminary examination, the court will schedule a probable cause conference. That is a hearing and an opportunity for your attorney to meet with the prosecution to discuss your case for any potential issues or resolutions. Your probable cause conference will be November 20th, 2025. That will be at 9 in the morning in person at the 14A1 District Court in Courtroom C. So 14A1 is the courthouse that's located basically above where you are right now at the jail. Lastly, the court will set bond. Bond is set in all cases, and the purpose is two things. One is to ensure your appearance at future court dates, and the other is for the protection of the public. So the attorneys want to address bond, please.
Yes, Your Honor. Thank you. Is the court in receipt of a bond form? I did not see one in our file.
I don't have.
Okay. It appears, based on my minimal opportunity to review the case, that this stems from an incident that spanned a time period of about, January to April of 2020. So nigh on to almost 6 years ago. It was charged fairly soon thereafter, looks like maybe June 20th. A quick review of criminal history information in our file leads me to the conclusion that there is no prior or in the intervening period of time charges, convictions, anything like that. Judge, I think I'd be hard pressed to ask for anything more than a PR with perhaps a cash as a backup in light of it being a felony charge. And certainly would request no contact and no go to. It looks like our victim is listed as a Kelly Thomas, who is either the owner or manager or operator of that Look Insurance Company. I could try pretty quickly to see if I can find the location of the Look Insurance Company if that's not readily available to Your Honor. And I think really those would be my only requests in addition to all the standard bond conditions. Thank you.
Attorney Yagi.
Thank you. I won't go into too much detail. Obviously, we would join in that request for personal bond or the recommendation for personal bond. Ms. Mitchell is gainfully employed. And just so the court's aware, she's employed at a completely different place than the place that's listed on this complaint from, over 5 years ago. So I did discuss with her that there would be a no contact. She understands that. She's completely fine with that. So with that, we would ask for personal bond with the standard conditions.
Ms. Mitchell, at this time, the court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. You are not to leave the state of Michigan without the court's permission. You are not to have contact with Kelly Thomas. Court says no contact. What the court means is no in-person contact, no contact through the mail, no contact over the computer or phone via phone calls, text messages, email, social media, the internet in any way, shape, or form, or through third parties. You are not to go to the location of Look Insurance. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court, the next one in this matter being that November 20th probable cause conference. Any questions about the conditions?
No.
Okay. These conditions will be entered into the Law Enforcement Information Network. They will be readily accessible to any police officers that you may come into contact with. If they have probable cause to believe that you have violated one of these conditions, they can arrest you on the spot, and you'll be held for a bond violation hearing date in front of a judge who may revoke your bond and set a new, more restrictive one. At this time, the court will set a $5,000 personal recognizance bond. So what that means is you are not required to post anything to get out. Basically, you are promising to appear for your next court date and to abide by all of the bond conditions. If you fail to appear or violate any bond conditions, then a bench warrant may issue for your arrest. Your bond could be revoked entirely. At a minimum, it would start at $5,000. Any questions about anything I just said?
No.
Okay. Anything else from counsel?
No, thank you, Your Honor.
No, thank you.
Okay, thank you. Then, Ms. Mitchell, you are free to go to the door and tell the jail that you are finished. Your hearing is concluded.
Okay, thank you.
Hello, can I have your name, please?
Yes, ma'am. Adrian Bryan.
Now calling case number 25F21746. This is the people of the state of Michigan versus Adrian Joshua Bryan. Appearances for the record, please.
Yes, Your Honor. Katie Rizmersky for the people.
Laura Yagi, Assistant Public Defender, requesting appointment with and on behalf of Mr. Bryan.
Thank you, Attorney Yagi. And can you address the plea?
Yes, we would waive the formal reading of the charge and stand mute at this time.
Bryan, you have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings. That is before, during, and after trial. You are not required to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that last part doesn't apply to you, don't worry about it. Do you have any questions about your rights?
No, ma'am.
So because this charge is considered a felony, you have the right in this matter to a preliminary examination that must be scheduled within the next 21 days. A preliminary examination is a hearing held before a judge where the prosecution must present sufficient testimony and evidence to establish that probable cause exists to believe that a crime was committed and that probable cause exists to believe that you committed the crime. So it's a hearing to determine whether or not the case is strong enough to go to trial. If the court determines that it is strong enough, then the case will be bound over, that is transferred to the circuit court, which is where your actual trial will take place. Any questions about that?
No, ma'am.
Okay. Prior to the preliminary examination, the court will schedule a probable cause conference. That is a hearing and an opportunity for your attorney to meet with the prosecution to discuss your case for any potential issues or resolutions. Your probable cause conference will be November 20th, 2025. That will be at 9 in the morning in person at the 14A1 District Court in Courtroom C. 14A1 is the courthouse that's located basically above where you are right now at the jail. Lastly, the court will set bond. Bond is set in all cases, and the purpose is two things. One is to ensure your appearance at future court dates, and the other is for the protection of the public. So, can the attorneys address bond, please?
Yes, Your Honor, thank you. Again, in light of an absence of a criminal history and taking into consideration the nature of the charge, I see no need personally for anything more than a personal recognizance bond. Again, I would recommend perhaps a cash backup in light of it being a felony. I believe that no contact has been requested on the bond form that was submitted, and that's no contact with who I believe to be the victims in this matter, and we agree with that request as well. Thank you.
Thank you. Attorney Yagi?
Thank you, Your Honor. We would request a personal bond as well. Mr. Brian is gainfully employed, and actually it's his third day at his new job, and he's really hoping to be able to go back to work, to be able to keep it, to support his partner and his family. And I won't go too much more, but we'd request a personal bond with the standard conditions. I did discuss with him that he would not be allowed to have contact with the individual involved.
Thank you. At this time, the court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. You are not to leave the state of Michigan without the court's permission. You are not to have contact with Anastasia Gibbs or Jacqueline Page. When the court says no contact, what the court means is no in-person contact, no contact through mail, no contact over the computer or phone via phone calls, text messages, email, social media, the internet in any way, shape, or form, or through third parties. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court, the next one in this matter being the probable cause conference on November 20th. Do you understand all of the bond conditions?
Yes, ma'am.
Okay. These conditions will be entered into the Law Enforcement Information Network. They will be readily accessible to any police officers that you may come into contact with. They have probable cause to believe that you have violated one of these conditions. They can arrest you on the spot, and you'll be held for a bond violation hearing date in front of a judge who may revoke your bond and set a new, more restrictive one. At this time, the court will set a $3,000 personal recognizance bond. So what that means is you are not required to pay anything to get out today. Basically, you are promising to appear for your next court date and to abide by all of the bond conditions. If you fail to appear or violate any bond conditions, then a bench warrant may issue for your arrest. Your bond could be revoked entirely. At a minimum, it would start at $3,000. Any questions about anything I just said?
Yes, ma'am. Just for my own personal record, I'll be sent this information regarding the date and times and whatnot as well.
Yes, I believe you should receive paperwork before you leave the jail. All right. You can also reach out to the public defender's office. You can also reach out to the 14A1 district court.
Okay.
Okay, if for some reason you don't get the paperwork. So, all right.
Yes, ma'am. Thank you.
Okay, then you are free to, well, actually, wait, to the attorneys, was there anything else?
No, thank you.
No, thank you, Your Honor.
Thank you. Then, Mr. Brown, you are free to go to the door and tell the jail that you're finished.
Yes, ma'am.
Good morning, how are you?
Good, thanks for asking. How are you?
I'm good, great.
Well, would you introduce yourself to the Parole panel? Tell us your name, DOC number.
Okay, Jonathan Beckley, DOC number 426869.
Right, and let's see. Let me just read some identifying information into the record,
Yes,
Mr. You're classified as a fifth, that's fifth felony
Yes,
of
ma'am.
currently serving a 29-year sentence. You were sentenced. Well, your sentencing date, I'll say, is July 16, 2020. Possession of a firearm by a convicted felon, possession with intent to distribute methamphetamines, and aggravated obstruction of the highway.
Yes, ma'am.
So your parole eligibility date is passed. It was January 14, 2025, and you do have a good time date, mandatory release date, December 12th of 2026. Is that right?
Yes, ma'am. Yes, ma'am.
So
Correct.
before we get started on our interview, is there the officer still in there with you?
Yes, ma'am. Oh, well,
If I can get her.
in this meeting,
I just would like to know what any of y'all could tell us about Mr. Beckley before we start our interview.
oh, the warden and the chief of police is gonna speak for me,
Okay, good.
but
Warden.
I'm waiting on them. Yes, ma'am. Here's the DOC coordinator here.
All right, well, go ahead, sir. Introduce yourself and tell us what you think about Mr. Beckley. Tell us how he's doing.
Good morning. My name is Christopher Johnson. I'm the DOC Transition Specialist here at Riverbend. Mr. Beckley has been doing a good job here at Riverbend for the past 2 years that I've been here. I know of him being a trustee and been doing extremely well with communication with the warden, because I'm always seeing him talking to the warden. I'm always seeing Mr. Beckley helping out with anyone around the facility. He has completed several of the CTRP classes as well, and he's always been a willing participant in the classes. He makes sure that everyone is in class and they're doing their assignments, and everyone's participating, and everyone pretty much looks up to Mr. Beckley in the class because of the fact that he does participate, and he's always extremely knowledgeable about the subject material that we're discussing.
Well, that's good to hear. Thank you.
Yeah, he's definitely a good guy.
All right. Well,
May I ask a question?
Sure.
May I ask a question, sir? Has he taken his pre-release?
No, he's not taking a pre-release class yet.
Okay, so he also signed a form June of 2025 saying he refused to take that class. He said, reason refused, I have taken all classes. Particular program or service refused. He says all. That's was a part of our file. So he actually refused to take pre-release.
No, he's not refused to take pre-release. He refused to be transferred to a different facility at that time.
Well, that's not what
Because
this says.
Because with his participation with the staff here, he's always involved in doing a lot of maintenance work and additional items around this facility.
Mr. Natsa, do you see the page I'm referring
I
to?
Yes, I do, and I understand what the transition specialist is saying. So you do offer pre-release there.
Yes, ma'am. 50-hour pre-release class.
Okay. And he has not taken it.
Correct.
Okay, that's all I need. Thank you.
He has not taken it just yet, but usually I get that class done it takes him about 2 weeks to get that class done. I spend a lot of time with the guys before they're discharged.
Good. Well, thank you. We appreciate it. Anybody else there that wants to speak on his behalf, Mr. Baker?
I'll get the ward.
Thank you. Boy. Good morning.
Morning, how you doing?
Good. How are you this morning?
I'm fine.
So for the record, sir, would you just introduce yourself and then tell us what you'd like us to know about Mr. Beckley?
Yes, I'm the warden at Riverbend Detention Center. Mr. Beckley, since his stay here, he been a real good trustee, never been in trouble here, been very helpful to the facility. And I think that if y'all give him an opportunity to go home, I think he'll be a great upstanding citizen for this community, and he's just a well-rounded, great guy. And I think that through his stay here, just became a better person. I talk to him kind of often, and I'm a pastor on the streets also out there, and so I put the word in him also.
Good. So he's been there for 4 years.
Yes.
Has he ever had any write-ups?
No.
All right. Well, good. Well, we appreciate you taking time to come speak with us today.
Yes.
Thank you, sir.
Miss Bill.
So now we got the chief.
Yes, ma'am. The chief of police.
Good morning, chief.
Good morning. How are y'all today?
Good, thank you.
Good.
Tell us what you want to tell us about Mr. Beckley.
Well, JB, as we call him here, he's been working out here in our maintenance shop with the lady out there that does all of supplies and everything else. He's been out there for, I don't know, 4 years.
Yes, sir.
About 4 years. He's been a model guy, feel upstanding. And I've had no problem with JB whatsoever. He's a good guy, being around the last 4 years. So,
Okay. Yes, sir. Well, we sure appreciate you coming in and talking to us. That means
yes,
a lot.
ma'am.
Appreciate it.
I appreciate y'all and whatever y'all can do for my man. Hopefully you can help him out. He's I'm ready to get him out of my hair.
I don't know how you're gonna run your warehouse.
Well, I don't know. That's the thing, is we're gonna miss him out there for sure. That's the whole thing. So, but thank y'all. I appreciate y'all's time.
Yes, sir. Thank you.
Yes, ma'am.
All right, Mr. Beckley, excuse me.
Yes, ma'am.
So what happened to you? I say that because you've a fifth offender, you've been in and out of jail, and suddenly in the last 4 years, you're okay.
Yes, ma'am.
Wow.
I understand, trust me. Miss Cheryl, I lost my mind out there. I grew up in a great family. Nobody done drugs. I was great. My mom died, and I kind of lost it. You know what I mean? I kind of lost it. But I reflect on everything I did, and I thought about all it eats me up inside. All the people I think about, families that I messed up with drugs, and you know what I mean? It just eats me up inside. And I know it ain't right. I took all the classes, and I think about it every day, and I pray, and that ain't what I want. I'm tired of jail. I don't want to come back to jail. I want to be a productive citizen, a productive person in society. I'm sick of this. Warden Hedgeman and the staff here, they mentor me every day, and I took that and I mentor all the guys in here. I'm just tired of it, Miss Cheryl. I'm just tired of jail. I know one thing, if I get paroled, you'll never see me again here. I promise you that.
Well, you know, but
Yeah.
you've had probation or supervision, good time supervision before, and you've been revoked more than once.
Yes, ma'am, I understand that. I mean, I know, but I promise you, I mean, I understand if you deny me, I understand, I'm not mad at you. You know what I mean? I'm not, no hard feelings.
You're not.
There are no hard feelings,
Right,
because
but
I
let
understand.
me ask you, hold on, let me ask you. What would be your plan? Obviously, when you got out before, you would go back and to the same places and do the same thing. So what's different now? Where would you go?
Well, I own rental property, and I'm gonna keep all my houses rented out, and I secured a house here. And when I get out, this is where I'm gonna stay. I'm staying here in this parish,
Where's your rental property?
in Caldwell Parish.
Who's
Right.
managing that for you?
I actually kind of manage it myself, but over the phone, but I got a guy that's renting one of my houses, and he's the one that takes care of everything. I just cut the rent down a little. Yes, ma'am.
How long you had that? You've always had that.
I've had that since my mom died, 2016. I inherited it, yes, ma'am.
Okay. Well, we do have a letter of support in the record from the sheriff. I mean, he's really pleased with your work at the warehouse. So I see you do have risk management, I guess the substance abuse 1 and 2,
Yes, ma'am.
anger management, parenting, thinking for change, because you have 400 and some odd days of good time credits. But you never did, you completed the 11th grade. Do you have your GED?
No, ma'am, I never got it.
Have you ever tried?
I tried one time, and I failed. I think it was math or something. It's been a long time ago. Yes, ma'am. It's been a while.
Do they have that there? Do they have that
Yes,
opportunity?
yes, ma'am, but it takes so long. I work all the time, Miss Cheryl. I mean, I understand. I work all the time. I work a lot, and I know that's no excuse.
I say
No,
that.
no excuse.
So you've had any job skills training formally?
Not here, no, ma'am.
Yeah.
I'm a certified welder.
Okay.
That's what I did for a living. Yes, ma'am.
Okay. So you were a drug dealer or user or both?
I sold drugs to support my habit, but I
So
never
you
sold. I never sold no big drugs.
Well, it doesn't matter.
I mean, it doesn't matter a little bit or a lot. Yes, ma'am. I understand, Miss Cheryl. I understand. Trust me, I understand.
So why do you think you're going to be successful this time as opposed to having failed so many times before?
Miss Cheryl, because I'm sick of it. I'm not the man I was then. I know what I got to do. I got to stay away from everybody that I used to know. Everybody. That's the reason I'm gonna move here. I don't want no part of nobody that I used to know, but my children.
Where are they?
I got one in Tennessee, one in Caldwell, and one in Winsboro.
Well, the Caldwell officials believe that you're a menace to their area and you're a career thief and a drug dealer. You apparently created havoc in that community.
Yes, ma'am. I ain't never stole nothing.
Well, you never stole anything?
No, ma'am.
Let's see. Maybe I messed up that. Let's see. Illegal possession of stolen things?
Yes, ma'am. Somebody sold me a stole four-wheeler.
Well, felony theft in LaSalle in 2009. Caldwell, theft over $500. Well, that was dismissed. So that's probably illegal possession. Here's another illegal possession of stolen things in 2018.
think that was the four. That's the same one. That's the four-wheeler.
So tell us what you did to get in jail this time.
Well,
Summarize it for us.
okay. Well, my mom passed away and she had a bunch of guns in the house. And the police came, the guns was there. I knew the guns was there. I shouldn't have had the guns in there, even though they registered to her, even though they was her guns. It was wrong to have the guns. And I knew better. I knew better. But I mean, it's no saying that, you know what I mean? It's just, I knew better. You know what I mean? I knew
Yep.
better. I'm a country boy. I've been around guns all my life, hunting and fishing. But I surely know now that I can't have no gun or in no house with no gun or any of that. So,
What about obstruction of highway? What was that?
well, I didn't stop for the police and they stripped my truck. So that was destruction of highway commerce.
Yeah, you put a lot of people in danger for that.
Yes, ma'am. And I understand that. I put people in danger all my life, Miss Cheryl, just doing dumb stuff. And you know, all I can say is I apologize to everybody, and I'll never do that again.
How you gonna stay away from all that? How you gonna stay sober? You said you have your own drug issues. I know you took the risk management class, but
Yes, ma'am.
when you get out,
Everything
I know they're everywhere in prison too, but you'd be exposed to it everywhere.
Yes, ma'am. I have a great support system, Miss Cheryl. The warden lives right down the road from here. I'm gonna go to his church. He's gonna kind of supervise me. The chief of police here also. I make some great friends here. And I know if I stay here and stay under them, I'll be just fine. Actually, they'll come whoop my butt if I do mess up.
All right. Where's your family today? Did you know you were coming to see us today? Obviously, because you arranged for all these folks to come talk to us.
Yes, ma'am. I even had a paralegal and a pastor that was supposed to be on my be here. I just talked to him, but they never give him the code to log in.
Well, sorry to hear that.
Yes, ma'am.
All right. Well, I'm
The
just. Go
only
ahead.
family I have left is my children. Everybody else passed away.
Yeah. All right. Well, that's all the questions I have. Ms. Ledoux, any questions?
Well, I'm still concerned that we do have the issue of not having pre-release our GED, and those are mandatory. So,
Ms. Stapleton?
And myself personally, I know you sound like a good old boy and you're getting along with everybody there great and everybody's your buddy and friend. But I'm gonna tell you what, the things you've done are significant as far as criminal history and possession with intent to distribute methamphetamines, stuff like that. What about the victims that that caused? And you know, that high-speed chase, who could you have hurt then? I mean, you say you did dumb and stupid things, but you're not a little boy. You're not 16-year-olds doing it.
I'm not.
So, and you've had time and time again chances.
Yes, ma'am. I understand. I
So-
completely understand.
I'm the type of person I wouldn't want to put my name next to something like this. So I'm just going to tell you up front. I think 4 years out of 29, after all you've done, I don't trust my name being next to this.
I did 8 years off of 29, man.
All right, well, 8.
Yeah,
8 out of 29. Okay. But a lot of criminal history. Severe.
Yes, I understand.
Excessive. Okay.
I understand.
All right. So I don't see any other questions, Mr. Beckley. I'm gonna go ahead and vote first. I agree with what everybody here has said. I do believe that you are a certified welder, so you do have the job skills training. So I think you meet the educational requirements. Unless you have the pre-release training behind you, and I don't know if they do that there, do they?
You do pre-release? Yes, ma'am. Yeah.
I put a lot of stock into what the warden and the chief has said, and along with the letter from the sheriff's office, they know you. They've been with you for 4 years. The fact that your reentry plan, you recognize you can't go back to Caldwell, you need to, and you've made arrangements to change your people, places, and things. I think with their help, I think you'll be successful. So I'm going to give you a chance and release you a little early. You get out next year anyway.
Yes, ma'am.
After you do complete that pre-release program.
Mm-hmm.
And then you would have to submit to regular random drug screens and then have a curfew every night unless you're at charge or at work from 9 p.m. to 6 a.m. and then whatever conditions your parole officer would put on you. But
Yes,
I'm
ma'am.
just one vote. It requires a unanimous vote. So
Yes, ma'am.
I would give that chance.
Yes, ma'am.
Ms. Ledoux.
Mr. Blackley,
Yes, ma'am.
I believe people change. I'm not sure I'm hearing the kind of verbiage I would like to hear to show that you've changed. But as Ms. Renatza says, there are other people who are speaking on your behalf that
Yes, ma'am.
are around you. You do have to have the pre-release. So I will concur with my colleague, and you must take the pre-release prior to being paroled. And that's my vote, is to condition a release upon completion of pre-release.
Yes, ma'am. Thank you.
Mrs. Staples.
Okay, Mr. Beckley, I like the conditions that Ms. Renassa just spoke about. I know that the pre-release is important with Ms. Ledoux. And you know, you've had some significant people put their good name next to you.
Yes, ma'am.
But once again, you'd be letting down not only yourself, but a lot of other people. You know,
Yes,
if
ma'am.
you didn't follow the instructions here. So today I'm going to defer and concur with my colleagues and concur with their conditions to approve.
Thank you so much.
So you still got a little work to do. You got to do the pre-release program. And I'm going to add, because of the I know you got the rental property in Caldwell Parish, but for the duration of your sentence until you're off paper, I don't want you going back to Caldwell Parish.
I'm not, Miss Cheryl. I promise.
I've come to see you.
Yes, ma'am.
All right. Well, don't let us
Okay.
down.
I'm not, Miss Cheryl. I promise. Thank you so much.
Look,
Okay, can I ask one question before we go? So
What?
what do I do when I try to finish this pre-release? How does that work?
You don't worry about that.
yeah, you don't have to worry about that. We monitor that. They let us know when you're done, and
Okay.
then they'll process our paperwork for release.
Okay, thank y'all so much. I won't let y'all down.
You make your parole officer your best friend.
Yes, ma'am.
All right. Good luck.
Thank you.
Approved?
Yes, sir.
Right, I'm appointing the public defender's office to represent you, ma'am. Please listen to Mr. McDaniel and we'll see where we go in this case.
Your Honor, I spoke with Ms. Richardson thoroughly this morning about this case. Went over the options with her about getting out of jail, possibly conditional release, possibly cash bond, possibly ROR, with no criminal history, a school teacher, and also went over the offer with her, Your Honor. And after discussions with her, she just wants to go ahead and resolve this case this morning. With the understanding that she'll be adjudicated guilty, 11 months, 29 days probation, $1,078 in fines, 50 hours of community service, DUI school. She'll have to take substance abuse counseling, double the amount normally, and probation will determine what that is. There'll be a minimum driver's license suspension for 6 months, and this will resolve this case today. She has signed a plea form and right to jury trial and call witnesses.
Thank you, Mr. McDaniel. Mr. Mitchell's that agreeable with the state?
It is, Your Honor.
Ms. Richardson, did you hear that agreement?
Yes, sir.
And Ms. Richardson, do you have any questions about that agreement?
No, so will I get all that information? No, sir, I don't have any questions.
All right, is this a plea you would like to enter, ma'am?
Yes, sir.
Ms. Richardson, I'm going to accept your plea of no contest to the one count of driving under the influence. The judge you guilty of that offense, sentence you to 11 months and 29 days probation. Florida law requires certain mandatory conditions for DUI, Ms. Richardson. I've got to impose those. That's $1,078 court costs and fines, successfully complete substance abuse counseling. Since your breathalyzer, or this was a breathalyzer case, since the breathalyzer was over 0.20, I require twice the counseling, but your counseling, if you go through the DUI school, that's going to satisfy a vast majority of your counseling. That DUI class is 16 hours.
Yes, sir. So what we've been doing previously is if she enrolls within 60 days, not completes, but enrolls, they're running behind, then she gets 16 classes credit towards the 24, and she'll have 8 more of what you've done previously.
Thank you. So the class is basically an hour long. So when you go to the DUI school, that's 16 hours. So as long as you enroll within 60 days, that 16 hours down there, basically you get credit for 16 hours of class, and it would only leave you 8 hours of class left. Ms. Richardson, I'll have to, by state law, have to order 50 hours of public service work. And I do recommend the minimum driver's license suspension, ma'am. I believe that's going to be a 6-month suspension. Ms. Richardson, there's possible early termination. What I mean by that is it may be possible to get off probation early. Ma'am, in order to get off probation early, you have to do half the probation. So in your case, half the probation would be 6 months. And Ms. Richardson, you've got to get everything done to stay out of trouble. Now, DUIs, it's hard to get off early because state law sets the fine so high. But if you can get everything done early, then good for you. There's a good chance of getting off early. Sometimes that may take 6 months, 7 months, 8 months. But if you get everything done early, you'll get off early as long as there's no violations and you're in good standing. Ms. Richardson, what's going to happen next is this. They're going to let you use the phone if you need to. For transportation purposes, they're going to let you get dressed in your regular clothes. They're going to bring you to the courthouse. The reason for that is the courthouse is where the probation office is at. Once you get to the probation office, you'll meet with the probation officer. Mr. Goodson will go over the probation order with you. He'll give you a chance to ask any questions about the probation order. He'll give you a copy of all the rules in writing of probation, and then you'll be free to leave. I'm going to ask your parents and your family if you have transportation. Someone's going to go pick her up. Usually it's 30 to 45 minutes. She'll be downstairs in the county probation office. So your family says they've got transportation covered, Ms. Richardson. You don't have to worry about that. There'll be somebody here to pick you up when you get here. Do you have any questions?
No, sir.
Does the family have any questions? Mr. Mitchell?
Your Honor, I think you may want to address the possibility of an interlock device, given that the BAC was so high. I think she's pleading to an over 0.15, so there is a possibility of that. I'll put on the record that the state is not requiring that she get an interlock device, but I know the DMV may enforce that.
Did I don't know if I asked you, did I ask you if this was agreeable with the state?
Yes, you did.
Okay. So Ms. Richardson, what Mr. Mitchell's talking about is.
I have discussed
Go ahead,
that
Mr.
with her,
Hagan.
Honor. I have discussed that, and I didn't ask the state, but it sounds like they may be wanting to drop it below 0.15. Is that accurate, Jake? Or, I mean, I did discuss that with her.
Not in this situation, given that it's over a 0.2.
So, Ms. Richardson, the state of Florida may make you do an interlock device. In fact, the statute says that you have to, but that's to get your license back. That's not a condition of probation. The reason I don't make it a condition of probation is because we don't have reasonably accessible providers at a reasonable cost in this area. At least we haven't in the past. But even though it's not a condition of probation, the state of Florida very well may make you do it to get your license back, to get your license straightened out. Ms. Richardson, does that change your mind about wanting to enter this plea, ma'am?
What was? Probation, right?
Yeah.
Regardless?
I don't think it changes her mind. I don't think you are, but I also advised her that, you know, the last few cases I've had, they've had to have special insurance that costs several $1,000s. You know, and I advised her that also that, you know, I don't know how the special insurance works, but maybe Jake knows, but I advised her that also. And none of that changes your mind though?
I don't think so. I don't know about, I don't think so.
Ms. Richardson, is this still what you want to do, ma'am?
Yes, sir.
Okay. So, Ms. Richardson, your
you-
family will be here to pick you up, ma'am, in 30 to 45 minutes.
One
And,
second, John.
Sure.
Give me one.
Well, they're muted. Good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Thursday. We're going to hang here with Judge Mercer for a little while, and then there's a whole bunch of other places we can go after that. I've currently got my eyes on about a dozen different courtrooms across the country. Decent amount going on today. We've got bond hearings and trials, and you name it. So we'll find stuff.
The 20th. Okay. Because I know we had some holidays in there. I didn't know if that affected it. Yeah.
Mr. Richardson, I've got several more cases I've got to hear from. If you want to have a seat, we'll come back to your case. If you want to think about it some more.
Think of it. Just have a seat.
Okay, thank you.
Sure. Next case is with a has friends or family here is Jeremy Collins. Mr. Collins, good morning. Mr. Collins, your mother and your fiance are both in the courtroom. Mr. Collins, you're accused of 1 felony and 25 misdemeanors. So I'm gonna go through those charges. The felony charge is 1 count of unlawful possession for sale or selling deer, which is taken in violation of Florida freshwater fish and game laws. Then you're charged with 9 counts of violation of Florida statewide bag limit. You're charged with 4 counts of violation of administrative code regarding hunting antlerless deer, violation of antlerless deer permits. You're charged with 4 counts of exceeding the antlerless deer bag limit. So one of those are bag limit, and one of those is taking them out of season when you can't. You're charged with 2 counts of taking a deer or other animal during archery season without an authorized weapon, in other words, by a firearm. 3 counts of unlawful to kill deer, doe, or fawn with less than 5-inch horns. And it appears 1 count of unlawful taking of deer at night with a gun and light. And lastly, 1 count of possession, sale, purchase of a animal that's prohibited by the commission. They're accused of selling deer meat. So you're charged with 25 misdemeanor charges and 1 felony charge. That's what I'm seeing here on this warrant and on this complaint filed by Florida Game and Fish Commission. I'm going to listen to the attorneys, Mr. Collins, and then I'll address your bond status. Mr. McDaniel, anything on behalf of Mr. Collins?
Yes, Your Honor. Your Honor, he does have a job. He's working. He's got an 18-month child at home. Obviously, besides that PTI that he got recently, he has no criminal history. So, we'd ask the court for some kind of reasonable option for him to get out of jail and, to come back and take care of this. And he's locally, he'll be back for any court hearings, Your Honor, sets, and he's not going nowhere.
I want to get
Mr. Mitchell.
I think that's reasonable, but we would also want the added conditions of no hunting, no fishing, and no possession of firearms.
Okay, so let's take those separately. I'm going to set your bond at $5,000 on the felony charge based upon, it appears you're very cooperative. It appears that you admitted to most of the allegations. I'm going to set your bond at $1,500 each on the misdemeanors. So you have 25 misdemeanor bonds of $1,500 and 1 of $5,000. Your total bond is $37,500. Excuse me. The $37,500 is for the misdemeanors. When you add the $5,000 to it, that would be $42,500. Your total bond is $42,500, cash or surety. You can go through a bondsman. That's what surety means. The reason I'm setting you the bond is because of the sheer number of charges, and I would never consider a conditional release for someone with with 26 charges with this kind of evidence against you, significant evidence, it appears. So that's your bond. The next question, Mr. Mitchell's making a request for no hunting and no firearms, and you said something else?
Yeah, I said no fishing, but that's force of habit, just no hunting and no firearms.
So there's a request from the states for condition no hunting and no firearms. Mr. McDaniel, would you like to be heard on that?
Have anything objection against those? I would just object mildly to just because the number of fish complaints or hunting complaints that, $42,500 bond seems excessive for, someone with, really no criminal history and local ties, but just a mild objection, Your Honor.
I understand. I appreciate that. Mr. Collins, the sheer number of times you've allegedly done this and the evidence against you is why you're getting the bond. This is not a one-time incident. It does not appear. Here's you've admitted to multiple criminal actions based on the complaint that's been filed. I'm going to have a condition of bond that you not possess any firearms and that you have no hunting. You cannot hunt while this case is pending. So if you get caught hunting by law enforcement, that will violate a condition of your bond and you can go to jail with no bond. So Mr. Collins, your hunting days are over, at least for a little while, and we'll see what happens when you get over to circuit court. Let me see if anybody has any questions. Mr. McDaniel, anything on behalf of Mr. Collins?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
Does a family have any questions? So whether you go through a bondsman or whether he puts up the money himself, it's entirely up to y'all, but you have the right to go through a bondsman. And what they charge you is they negotiate. Usually it's around 10%, but that's up to the bondsman. 10% of that would be a little over $4,000.
And I've already got his firearms when all this stuff is done, as long as he don't live in my home.
He just can't have access to them. As long as some friends or family can have them, he just can't have access. Okay. Mr. Collins, do you have any questions?
No, sir.
All right, sir. Wish you the best. Mr. Goodson?
Mr. Collins, you're still on PTI with Mr. Ham. You did check in for October 15th. Your next check-in date is November 15th. If you're in jail, of course, you won't be able to check in then. But if you do bond out, you need to make sure you come in and comply with your PTI conditions as set forth and see Mr. Ham this month, okay?
Thank you for clarifying that. So these charges allegedly occurred before you were on PTI, Mr. Collins, and since they occurred before, they can't violate your PTI. So if you don't post bond and you're in jail, then you're not going to be violated because you can't report. But if you do post bond, you need to keep reporting on that PTI so that you can get that case dismissed if that's what the state, I guess the state kind of has to do that because he's having before. Is that right, Mr. Mitchell?
Yeah, I guess.
Yeah, I don't think you can violate it for something like that. So, Mr. Collins, I wish you the best. You have something else? No, I said 1,500 per misdemeanor and then 5,000 on the felony. So it's 37.5 on the misdemeanors, 5,000 on the felony, 42.5 total. Cash or surety. All right, so that's it for individuals who have friends or family. Actually, it's not. We'll come back to Ms. Richardson at the end. The next case is Clyde Williams, Sr.
Judge, Judge, would you consider a cash bond on him? I'm trying to, have him. I don't know if you will or not, but I hate for him to see though.
So let me explain that to. I didn't mean to interrupt you. Let me explain that to his mom. So what if you go to a bondsman and they take 10%? Then that's their fee. They keep that. The advantage of a bondsman is some bondsman may take less than that. They may say, we charge 10%, but we'll take 5% up front and you pay us payments on the rest or collateral or whatever. On the other hand, if I convert it to a cash bond, then it's the same amount that you'd pay a bondsman. It'd be $4,250. The advantage to a cash bond is this: that money is held by the clerk of court until the case is over. If the charges against him were dismissed, that money is returned to whoever posted it. If the charges are not dismissed, that money by law is taken and put towards court costs and fines. So he's requesting a cash bond so that you don't lose the $4,250, essentially. Okay, Mr. Mitchell, what's the state's position on that?
I have no objection to a cash bond.
I have no problem with that. You've got a cash bond of $4,250. So to break it down for the jail, instead of it being $1,500 per misdemeanor, it'd be $150 per misdemeanor. And the felony be $500. That would add up to $4,250 cash. And there are some advantages to a defendant for a cash bond. I don't know if he can post it or you can post it for him, but that's an option he's requested. Okay. All right. Wish you the best, Mr. Collins.
Thank you.
All right, we're going to pause proceedings here for just a minute because Barbara was asking what the charges were. The long and the short of it, it appears he was taking deer illegally, whether or not he had a tag for any of them. took too many. It sounds like, if I heard it correctly, he was like selling it as well. So that's where some of this comes into play. Even if you have your own land, you are not allowed to just take deer on your own land. Dates back to, English common law. The wildlife is referred to as like the king's deer, the king's wildlife. So you can't just go and take it. You have to have permits, even if it's on your own property.
Next, we call 24 CR 2260, the state of Texas versus Taylor Levette Jackson. You are Mr. Jackson?
Yes, sir.
And you were here with Mr. Lang, your attorney, and the state's attorney is here. All right, we are here on an announcement, five cases total, is that right?
Yes, sir.
Okay, are they all similar allegations?
With the exception of one, one is an unauthorized use of a motor vehicle and the others are ag sexual assault.
It's like 4 cases of sexual assault of a child was carved out of 2 events.
Yes, sir.
December 11th and December 14th.
Right, juveniles. And then certifications, and some of the announcements have been to retain the certification material. I've talked with Mr. Nelson, and I think we're satisfied that there's a proper certification. If I could have one more announcement to give Ms. Moore, then we could see where we're headed.
Right, the other case is a separate
Unauthorized use of a motor
unauthorized use of a motor vehicle.
That-
Hold on. Thanks. He was indicted on October 30th of
Yes.
2024. What took so long?
Well, it was a grand jury indictment. Nobody knew the warrant was issued. And when he got arrested for the unauthorized use, that was when he realized that there was even an indictment for something that he did 9 years ago as a juvenile. And so that's how.
Well, they still count
Well,
when they're sexual assaults on children.
yes, but that's how he understood their movement. He did. That's why it's the way it is. That timeless.
Just saying. While I am waiting to receive some information here,
Yes, sir.
each of these are first degree felonies, except for the unauthorized use of a motor vehicle, which is a state jail felony. So you got 4 cases where you're looking at life up at the life in prison on each case. Do you understand how serious this is?
Yes, sir.
4 life sentences, which could be stacked, theoretically. Then the state jail felony carries with it up to 2 years in the state jail. Look at one thing. Brian, how's the family? Everybody well over there? That's the best we can hope for.
Kevin, Shirley's been in her house. I've had all the bouts with my in-laws, in and out of the hospital.
The, what are the dates on the bonds on the sexual assaults? Does it show? Like, what were the bonds on the sexual assaults? Was that on the same day? Something, you know. You're giving me 9/20/24, but I'm looking at a bond on May of this year. On that. Oh, for this unauthorized use of a motor vehicle, I guess, huh?
Yes, sir.
He was arrested 9/20/24 on all of the cases.
On all the cases.
And he bonded out 5/28/25.
Okay, even,
Sorry. I just wanted this last.
it's, he got arrested when they arrested him for the unauthorized use of a motor vehicle.
Yes, sir.
And then those other cases had been pending, and then they all collapsed on it.
And then they took him to a certification hearing prior to getting released.
What are your bonds on these aggravated sexual assaults of a child?
They're very
What are
high.
they?
Yes, sir. They're 100,000 apiece.
Yeah, I'm confirming that, Judge.
Who paid for that?
My father.
You know, this is your responsibility. You understand all of this,
Yes, sir. Yes, sir.
not your daddy's. This is yours responsibility. Welcome to the real world and grown up adulthood. And all of us, when we make a mistake, we've got to handle it responsibly. Are you going to do that?
Yes, sir.
Well, Mr. Lane's a very good lawyer. He can help guide you through this, but these are most serious crimes. Juries in this county deal with them severely.
Judge, incorrect in that bond is $100,000 on sexual assault cases, and on the unauthorized use, the bond is $6,000.
The one of the conditions of bond is that you cannot have contact with a victim of an offense. And with you, I'm adding a condition of bond. You're not to be around a child without alone, without some kind of chaperone of an adult. You understand?
Yes.
You're talking about children who are 6 and 7 years old. That would be an added condition of bond.
Yes, sir.
One error on these types of cases for a bond, and your bond will be revoked, and you will sit this out in jail until this can get resolved. There's hardly a more serious crime in the penal code than this. You understand? Okay, how much time, Brian, do you want on an announcement? 5, 6 weeks?
Yes, sir.
Is that good? Okay. All right, please get a resetting.
Thank you.
And also you, sir, Lamar, you gotta get resetting. And also you nor anyone on your behalf can have any contact with these victims. Do you understand? You or anyone, if I find out that someone is talking to them or the parents of these, you need my permission. And the lawyers have to do their job in investigating, but I don't want children who are victimized to be re-victimized or or manipulated during an investigation until all of this can get completed. All right, Arnie Koenig.
So we wait for the next contestant. Michelle asks in the chat, what was the crime? Lindsay says, if it's that serious, why is he out on bond? Well, it appears that we have crimes against minors. And why are they out? Because yet again, I question how seriously the court takes these matters. But, you know, we've discussed it time and again, and it just seems to continue to be an issue. Let's get back to Judge.
Which would otherwise be a state jail felony, except you got, well, 2 other state jail felony convictions in 2017 and 2021 out of Liberty County, Texas. Does that affect the punishment range on these?
Yes, sir.
To it. So the state jail felony, that would otherwise be up to 2 years in the state jail because of these prior convictions. This kicks up the potential punishment range to what would be a 3rd-degree felony range, up to 10 years in prison. We are all responsible in crimes. When a crime is committed, every person charged with the crime is subject to the result of the circumstances of the crime and criminal history. Those are the 2 parts of the equation that are part of the criminal system in dispositions of how somebody gets dealt with and the punishment. What are we going to do today, Brian?
Well, we've gone through a couple.
It was an announcement to that for today.
It was an announcement today. I tried to set up.
It's been a year since he was indicted.
Well, I've gone through a couple different prosecutors. At this point, we can set it on.
That's not unusual.
But I tried to give it this gas ball, but if the court, right now.
What do you want to do?
We're at an impasse. Right now, we'll put on the trial.
Sit on trial, right? Sit the trial. That's all language to get.
Well, you know, I like to talk. I'm a talker.
Everybody likes to talk, but you need to say something
I gotta say something.
when you're doing that. Randy Johnson.
Yeah. Yeah, I'm right in the back.
All right. Today, a status hearing is what we had planned. And the defendant, you are Randy James Johnson?
Yes.
Mr. West is here. Mr. Minaldi is your attorney. You don't object to him being here with you, right? Is that okay? Look, when you come to court, would you wear that at church? Why not?
I'm sorry.
Well, but nonetheless, yeah, leave a shirt in the car or something so that you can put it so it's decent. That's not proper. You know, and it just shows that this isn't, you don't have much respect for the whole process here. That's what this shows. And you should be, it's your liberty at stake. You're looking at up to 2 years confinement in a state jail. Okay. So he pleaded true back in June of this year. And what did we do on this? Did we just continue him on probation? All right.
Make some progress.
Okay. So on behalf of probation, the IMAC, let's get to the bottom line. Good news or bad news?
Good news.
Okay. That changes the direction we were headed in here this morning. Go ahead.
He has completed one of the courses that he was required to do.
How many does he have?
There are 2.
When are you going to complete number 2?
I get paid on Thursday and I'm gonna start on it then.
How long does that take?
It is the 32-hour course, so it can take some time. And then there was the theft class, and he did complete that.
I'm sorry.
The theft class, and he did complete that.
Good. What'd you learn?
Yes.
Give me an example.
Like with the theft, what I'm being charged for, like, I could have went in different ways instead of just bringing it to the street. I could have called and involved more people, speak up, said, do different things instead of trying to take it into my own hands and doing it.
I know you're talking about, you use I a lot, but you know, there's a victim here. In crimes, they're victims. And what about that? I mean, do you regret causing harm to someone? When it's a theft, generally it's a loss of something of value that they have, that they acquired, that they work for. Just like me grabbing for your wallet and taking it, and I say, it's mine now. You'd feel victimized, which you should, because you worked off for it. It's sweat equity that you can't get back. And the sweat equity was in something that you acquire. You see, sometimes it's materialistic, sometimes it's there are other forms of reward, but those are things that you can't get back again because you've already put the effort in. You'd have to duplicate it, which we only have about 80 years on the planet. So we don't have time to pay for the same real estate twice. You know what I mean? And that's the way it is for victims. So was there any restitution on this one? I'm always sensitive about that.
Yes. There was restitution.
Is there anything left?
Yes.
I don't like that. You've been on probation now for 1.5 years. How much is restitution?
1,500 in total, 1,350 is left.
You only paid $150 in a 1.5 years?
Wasn't working at first.
How are you now?
I'm working.
Well, how much can you pay toward this I wanted to go for restitution, please, first, and then we'll catch up on the other stuff. I can shorten probation for good behavior, but good behavior includes paying victims back. It would cost you less if you get it done quickly. Then we could, all things being the same, if you're doing fine, then I shorten it all. I shorten probations I can do it in 1/3 of the time. Like for 5 years, 1 year and 2/3, I can shorten it, which in your case would be almost there if you were doing everything fine. But until you can pay this victim off and take care of the other obligations on probation, then you're going to be dealing with me. What else do we need to do today? I want to know on the restitution, how much can you pay back a month? How much can you pay a month toward restitution? Right now. No, I'm talking about long term, not just, you've got a regular job, right?
Yes, sir.
Oh, okay, I'm talking about how much can you pay a month? So restitution and then pay your bills.
At least trying to balance everything, I can do 3.
Sir, 300.
Do 300. They just.
Okay, well, here's what I'm gonna do is order you to pay 200. You meet that goal. Because, and what's left?
1,350.
All right, so that's 6.5 months.
Yes.
State champion in number sense, man. Should have been an engineer, but no, I went into law. Okay. So I want to review this in 4 months. See how he's doing? Is that good? Anything you need to know about or ask so that you can complete your probation successfully? Okay, well, just get it done. Okay, Smith. Any problems come up? She's your guiding, you get lost in the woods. And a lot of people do on probation. They're about to make the wrong choice. She's your lifeline. You call her, you get advice. She'll guide you out of the problem. don't delay if there's an issue. Resolve it.
Right, just give me a reset.
Thank you.
I don't know how I did
Shane Myers.
that.
Okay.
I'm gonna give you a copy.
Shane Myers.
And that's what it said.
I believe all of the cases that we said, Your Honor.
Shane Myers has been reset according to my boss. And that's 3 cases. It's reset for what, though? It's a,
It's located on the docket that there's a third amended TRP that's on the way, so.
okay, when did we reset it to? Because I don't want to, when we modify, that means something bad happened that we need to address. Norman Marshall is next.
The first week of January, the defendant is in custody though.
Okay, the attorney knows that. Reagan, I guess, knows that.
Yes, correct.
Are you Norman Marshall?
Yes, sir.
This is about restitution. Who's on?
I
filed a motion to dismiss.
Oh, you got it? Oh, okay.
Yeah, here, Mr. Patch said.
You paid it off?
It was paid.
Yes, sir. The ticket,
Good for you.
receipt's right here. You can see it.
No, your word's good enough for me, sir.
Thank you.
And I got a motion that's right here to dismiss for fixing the mess. That case is gone. It's dismissed. Go and do well.
Do I get a piece of paper saying that?
Well, yeah, we can get you a parting gift like that, no problem.
Okay.
The best thing, though, is she's not, the best thing, we're gonna have to get it through the district clerk.
You're gonna mail it? Will you mail me something or?
We won't mail it.
She's gotta prepare it first,
Right, I understand.
and it takes
Yeah.
a day.
It goes over to the district clerk's office. That's where you can get a copy. Also,
Will they email me a copy or something? I'm 5 hours away.
Yeah, we can take care of
Or
it.
I can email it to James or something?
you can speak to the ladies across the way.
Okay.
And they can tell you how that.
Okay, James can probably take care of it for
If
me.
there's a problem, call us, and then you'll
Yes.
get something wired through your somehow. You don't need to
Okay.
drive it.
All right.
Yes, sir.
Thank you, Joe.
Okay, yes, sir. Rebecca McWhorter,
That was pretty sad.
how are we gonna get things done? If we reset them? Oh, I'm just asking. Nakia Washington? That's reset?
No, that's fine. Your Honor, Mr. Rank's listed on there, but not code. Okay, so I'm also. I would say I'm playing Mr. Riddick, but I'm actually playing this.
Good morning. I'm fine.
Yeah. Not falling on a chair.
Hi, you're Nakia Washington?
Yes, sir.
And here with Mr. West, your attorney today, the state's attorney and the probation officer is here. We have a first amended motion to revoke probation that had been filed a year ago, correct? Is that the most recent thing?
Yes, sir. I believe so.
And something doesn't make any sense. On first amendment motion, I've got that pleas of true were entered on paragraphs 2 and 3
and 8, I believe.
Hold on. But I have that dated 6/17/21.
Should have been 6/17/25.
25, okay. Okay. And I'm going, why in the world, what's 21 all about? And that's when the motion was filed on 6/21, the original motion. And we must have been talking about that when I was doing the writing. So on 6/17/25. Correct?
Correct, Judge.
All right. And, okay, on the next page, I've got 6/17/25. Why 21 got in my mind? And these were a specimen result, and it came back with marijuana, and then failing to report online. So, how are we doing, Ms. Martinez?
Your Honor, she has been reporting and she paid all of the restitution off.
Oh, that's great. So, she's been on probation since when? 19? Since April 19? And that was $2,033 restitution, correct? And this has been a deferred or unadjudicated probation, correct? The whole
Correct,
time?
Judge.
We've had her on probation for, let's see,
5 years originally.
5 years, and it's been 5 years. So, what can we do today? What do you think?
Well,
Don't help her. She's is it?
she's good. Yes, sir.
Okay. Any objection to me dismissing this case or her moving on with her life without a conviction?
You don't have my signature
Then
yet.
so it shall be done. Okay. Good luck. Good luck and good work. Thank you.
All right, it's time to get back to work. We've got several sentences, 3 set at 10:30 and 1 set at 11. The first case we're going to address is People versus Christy Elaine Benton. That's you?
Yes.
Miss Benton is here. She's charged with retail fraud in the 2nd degree and filed 251646 SM. She's represented in that case by Jordan Harden. She's also charged and filed 251723 with malicious destruction of property less than $200, and that is Ms. Harden. Mr. Bush represents the defendant in file number 241763, a retail fraud 2nd degree. The 2 matters that are set for sentencing are 1763 and 1723. 1 retail fraud, 1 MDOP. Another retail fraud was dismissed, I think, as part of this. Let me look. No, she pled in that case too. Miss Benton has been here a lot in the last couple of years. And I couldn't figure out. And the last time she was here, I gave her a large jail sentence, which resulted in her losing her job. But I felt it was appropriate. So she got out of jail, and here we are right back in it. So frankly, I needed some help. So I asked for a pre-sentence report, and one has been prepared by Matt Huff, who spent a lot of work on this. And I was embarrassed that I didn't realize the extent of your substance abuse issues. I didn't realize this was heroin and methamphetamine addiction. I thought it was just bad behavior. There are also other factors in here. Anyway, Matt has done an excellent pre-sentence report, which will be a place for us to start from. Ms. Harden, let me hear from you first.
Thank you, Your Honor. As the court has already indicated, Mr. Huff did a very thorough report to kind of highlight what's been going on in Ms. Benton's life as of late. The only update we would provide is that she does have employment. She's working at TH Plastics and has been there about a month. She reports that's going well.
I thought she told me she was employed again.
Yes, so she's working there. Things are going well. She's focusing on her sobriety.
What shift?
Third.
Okay.
Her partner is here as a good support system, and he's referenced in the report as well as a stable and a constant in Ms. Benton's life. And I think the recommendation that Mr. Huff has provided tackles the things the court's looking in reformation as far as addressing the substance abuse issues, getting a plan for long-term sobriety, as well as addressing the history she's got of the retail frauds. So we're asking the court in our files to follow the recommendation of Mr. Huff. I think it's fair and appropriate. When I met with Ms. Benton at the jail, I believe she was serving time on a retail fraud, and these had occurred prior to that. So I don't believe this is a situation, and I could be mistaken, but it's my understanding these were all that occurred before that sentence. So since she's been released, there's been no issues, and she's appeared for court. She met with Mr. Huff. I think the report, like I said, highlights things that we need to focus on to help Ms. Benton become a productive member of society. I think she's on a good start. So I ask the court to adopt Mr. Huff's recommendation today.
Mr. Bush?
Speaking with Ms. Benton, it's my observation that 30 days in jail was eye-opening for her. There was forced sobriety. She didn't like it there, doesn't want to go back, but that's all what we're looking for. I think Matt Huff was on target here, that we need to focus more on reformation and punishment. And I do believe that the probation and the programs that are involved in the pre-sentence report are appropriate. I would ask the court to follow the recommendation.
Ms. Camfield, you've been here, I guess, about 8 months now, 6 months. Soon this will all be part of your history too. But we've been dealing with Ms. Benton for 4 or 5 years. And now you're here and learning this constituency. What's your thought regarding this case?
Thank you, Your Honor. I've had an opportunity to review the files as well as Mr. Huff's report and recommendation. And I note that, you know, people do struggle with addiction, and they struggle off and on and have periods of sobriety, and then they use again and leads to poor decisions. Reference the request for reformation. It looks like there has been reformation before. She did have probation in 2008 for retail frauds as well. And then she did subsequently serve the jail term this year that Your Honor imposed. I do think that given the honesty and candor of Ms. Benton with her substance use, and some of these she didn't even clearly recall, it's certainly not an excuse for criminal behavior, but an explanation as to why she may have come before the court again in recent years. So I think that the recommendation is appropriate. I would ask that the court follow it. In a circumstance such as this, though, I do find someone of her age and experience level and prior probation has the knowledge to recognize that using again may lead to more criminal action. I might give a couple more days jail up front, or some community work service as part of the reformation. She did just serve a pretty lengthy time, so that may have been enough, but community service I think would be appropriate. This does entail a malicious destruction of property as well as retail frauds that have made companies and essentially then their customers victims when retail fraud occurs and prices rise. It goes to the community as a whole. So I just think other than that, the recommendation is more than appropriate.
Mr. Huff, you drew this tough assignment. And I think maybe it's your first time meeting in depth with this defendant. As everyone said, we're going to focus on something, trying to stop the behavior. I'm almost more concerned about the malicious destruction charge than I am the retail frauds. It's weird. She's in this car, which is reported as stolen, and it's reportedly stolen from her current boyfriend.
That's correct.
So he had reported the vehicle as stolen, and she was driving it, and she had a child in the car, and his son pulls up behind her to block her in to get the car back, and then she allegedly bashes into his Mercedes a few times. He realizes there's a child in the car, and he moves so she can get out. Now, she and the person that reported the car stolen are back in a relationship, and so it probably isn't exactly stolen. But smacking into his car with that car wasn't a good plan. I'm going to ask you about that, Ms. Benton. Anyway, for a history lesson, when I was prosecutor, I started the embezzler treatment group. Mr. Bush remembers it in its original form because I kept having embezzlements by women and retail fraud and property crimes, credit card fraud, NSF, retail frauds repeated. There was a common theme in that they had childhood trauma that was not addressed. So the embezzler's treatment program was originally primarily set up for women. And I used it a lot when I was the prosecutor, and I felt it was an excellent program. When I became judge, other people were less committed to it. The circuit court didn't use it. And it was for circuit court embezzlements, large $20,000, $30,000 embezzlements. There's a reason why that happens. So we've resurrected it through the court, district court, not community corrections. And it's available. So that's going to get at the root of the question. What I did not understand is the depth of your addiction. You're always so polite, so respectful, so quiet. As I mentioned, one time someone paid all your fines and costs. Then you just go out and do it again. And I couldn't figure out why you kept doing it. Well, there's two answers: addiction and childhood trauma. Mr. Huff, thank you for your report. Anything you'd like to add to it?
I would just, above what the report says, I would just say that, it looks like Ms. Benton, most people get a handle on their addiction or their problematic behavior earlier in life, but I think Ms. Benton, from speaking with her, is genuine about where she wants to be. I think she's put forward the vehicle, so to speak, to get to where she needs to be. And I think the 30 days in jail up front was enough to get her attention. Probation would be a good opportunity for some extra accountability over the next year or so to make sure that we just cement into her life a good foundation.
Ms. Benton, what would you like to tell me?
Pretty much everything that he says. Jail was a definite wake-up call. It's embarrassing. I think I just, I want to get over the substance abuse, and I just think probation is going to keep me held accountable to be able to get there.
I think so too. What were you doing when you were bashed into this kid's car with your boyfriend's car?
Well, I mean, he had pulled up behind me, but I never bashed into it. There was a backup cam in the car, and I did have a little girl with me. And he was parked far enough behind me that when I backed up in a little bit at a time, I never backed into the car.
Well, did your car hit his car?
No.
Pled no contest to that charge. The case I sent you to jail for, I did in August of 2025. It occurred in 2024. I sent you to jail on August 25th for 30 days. The MDOP is listed as having occurred on August 4th. So that was before you went to jail. The retail fraud in 1763 is listed as 6/8 of 25. And the other one is 6/28 of 25. So these occurred while you were on bond on the earlier one, but before you went to jail. So I gave you 30 days in jail, then these things came up. Now, what do I do now? Matt, as far as I can tell, with all of this, she only has 1 day of jail credit, is that correct?
It's a little bit sticky in regards to what you want to consider for, I think you have a lot of discretion in this situation. Because she was placed in probation, bond wasn't set in these, or wasn't posted in these until a few days before she was released from custody on the 30-day charge that she was already serving. So there could be some credit, so to speak, because she was released and there was a bond set.
Okay.
But essentially those 30 days were set on the other case.
All right. Well, I'm gonna do the probation in the retail fraud case. I organized my judgments so well that I don't have any general judgments. But I'll use this one. I have a couple. I have 2 left. In the MDOP case 251723, I'm going to order 1 day as a no contest plea. One day credit, 1 day, 0 fines and costs. Concurrent with the other cases.
Which file was that, Your Honor?
That was in 251723. She pled to retail fraud second in 251646. She pled to retail fraud second in 1767. And I don't need to put her on probation on both of those cases. We're gonna do the probation on an offense that has a 1-year maximum.
Which file is that, Your Honor?
The next one we're going to address is the retail fraud second that you represent her on, Mr. Bush.
And she pled to retail fraud third in that file.
Third, that's what I've marked here. And except I can't read my own writing, but yeah, it's third, 1767. So I'm going to do the probation on the 1-year offense. And 767. And 763. I'm gonna also do 1-day jail credit 1 day, concurrent with the other retail fraud, which is 251646. There is restitution, which will be included. One of the reasons why I never got clued into the addiction was that she was always working. She had some difficult jobs. Seems like she worked at Middle Technology, she worked somewhere else. And so I thought, wow, so it didn't flash a red light. We're going to do the probation in Miss Hardin's case, 251646. Laura, could I have some more general judgments? This is my very last one. There's no sense making you lose another job. I think I made my point with the first 30-day sentence. And these all preceded that sentence. Not gonna do it. Well, I guess I will. I'm gonna do a 24-month probation, which means you're gonna be on probation for at least 12 months. I guess I'll order 91 days, credit 1, leaving 90 days to serve. Of the 91 days ordered, 90 are deferred. I'm not gonna put you back in jail, make you lose another job that you just got. But you're gonna do a probation. The fine is 0. There's a $75 crime victims' rights fee, a $50 state minimum fee. I'm just going to charge 1 attorney fee. $960 probation oversight fee. The restitution figure is in the report.
Do you separate it by file number? Or are you comfortable with both files?
What's the number?
It's
367? 362.
Yeah.
To Walmart and Myers. Thank you. All right, no drugs and no alcohol, substance abuse treatment as tested. This one actually has the embezzlers group on it. It's a very good class. I had 100% approval rating. The people that were in it all said it was very worthwhile. You can't keep going like this, Miss Benton. You're wise enough to know that. You got a stable influence in your life, which you didn't have. So I'm encouraged here. Let's add those numbers up. 125 plus 150 plus 960 plus 362.30 is 1,597.30. Take 480 off it if you do this in a year, so you owe about $1,100. Is there a cost for the embezzlers class?
There is. I don't know exactly what the current rate is and if it's going to go up for the 2026 year.
Excuse me. At one time, I used community correction money to pay for it. But that was a different time. I was chairman of the Community Corrections Advisory Board for 35 years, and now Judge Stutzman has that privilege. But I want you to stay on the path you're on. And again, you're wise enough to know it. The other option is a long jail sentence and then death. Nobody wants that. Problem is you can't shop anywhere. You got kicked out of all the stores and then I barge. I guess you can shop at some stores, but you can't go to Walmart or Myers during the term of this probation. The community service idea was a good one, but you got enough to do. You're also to sign a release if we need information. All right, let's hope things get better from here. All right, Ms. Benton, you go downstairs and Matt will meet with you.
Headquarters, we've already introduced ourselves, and you can see from our name tags who we are here. We're going to be handling a case at LCIW. The case is about Brenda Thornton, who is requesting to be paroled at this particular time. And so we'll go to LCIW. And Miss Brenda Thornton, would you introduce yourself and give us your DLC number?
Yes, sir. Brenda Thornton, number 121327.
Okay, thank you. And Warden, we appreciate you hosting us. Would you introduce your staff there that's with us?
Yes, sir. Kristen Thomas, Warden.
Captain Asha Harris, security.
And we have Miss Thornton's attorney with us in here.
Okay. All right. Where's Miss Thornton's attorney? Okay, there you are. Okay, would you introduce yourself, please?
Yes, good morning. My name is Hannah Rose Grodell. I'm Miss Brenda Thornton's attorney, and I'm with the Louisiana Parole Project.
Okay, thank you. We appreciate you being there and the work that y'all do. Warden, just as a note of information, I noticed the last time we were there, the camera is really out of focus. We can barely identify who's speaking. So you might look at that when
Yes, sir.
we're offline sometime. We can conduct a hearing and that's fine, but might check on that.
Okay.
Okay, Miss Brenda Thornton, today is going to be your day because you've requested this. We want to know what you did to get you there. We've got all the reports and everything, and we've all read those, all three of us, and I'll be doing the questioning later on. But we want to hear from you what you've done and what got you there, what you've done since you've been there, why you think you're deserving of an early release, and then we'll go to the warden and ask the warden exactly what all your conduct has been while you've been institutionalized. Then we'll move on to your supporters. I'll introduce them in a little bit, and then those in opposition, and we'll introduce those. So to begin with, Brenda, today is your day. Go ahead and tell us what got you there and why you think you're deserving of an early out.
Yes, sir. I would like to thank the board first and foremost for allowing me to be able the opportunity to speak today. I would also like to acknowledge that I did not speak as openly as I should have previously. I have always felt responsible for the death of Johnny Thornton, but now I understand the extent of my responsibility. Before I speak about my selfish and harmful choices, I would like to apologize to my son, John Derrick, and to the Smith family of Renee, Billy Wayne, Jason, Greg, and Alicia. No words can ever truly express my deep remorse and sorrow for the pain, the heartache, and the continued loss that I have caused you. I know your hearts are torn forever by Johnny's death, and I also know that you feel his loss daily, and especially and certainly on days like today. I truly regret the pain and the suffering that I have caused you by Johnny's death and my continued silence since then. I am here today because I am responsible for the death of Johnny Thornton. Johnny was suffering from a previous back injury that led to a recent hospital stay. Instead of working on our marriage, I selfishly and wrongfully began an extramarital affair that subjected Johnny to the anger, the jealousy, and threats of a very volatile and violent man that I invited into our lives. Dennis and I had had multiple conversations, and when he began to make threats against Johnny, though I did not agree, I did not notify the police or family members about the threats, though I had multiple opportunities to do so. When Dennis said he was coming over that night, I knew that he meant harm to Johnny, and even though my 3-year-old son was at home with me, again, I did not call or notify anyone for help. When Dennis hit Johnny with the bat, while John Derrick and I were in the house, I did not call for help again. My silence allowed Dennis to brutally murder Johnny and forced my son to witness the cruel and violent attack on his father. My choices forced my son to live a life of pain, fear, and suffering. And I am so very sorry that I caused him that devastating loss of his father and so much more. I did not stop the attack before or during it. And even though I knew Johnny was seriously injured, I did not call law enforcement, nor did I notify any family. I chose to make misleading phone calls and to destroy the evidence. I have not been forthcoming about my role in Johnny's murder until now, and I chose the weapon of silence and fear. Because of my silence, Johnny was brutally murdered, and John Derrick was forced to witness. There are no excuses for my failures. I failed to end the affair. I failed to stop Dennis from coming over. I failed to call law enforcement. I failed to notify my family. I failed as a wife. And I most certainly failed as a mother to keep my son safe. Because of my failures, Johnny lost his life. John Derrick lost his father. and the Smith family lost a brother, an uncle, and their loved one. Over the last 37 and a half years, I have confronted my failures and my shortcomings through a commitment of learning, of faith, and service to others. Through classes like Life Healing Choices and Thinking for a Change, I have addressed the selfish, fearful, and harmful actions of my past. And I have learned the tools needed to be a positive member of my community. In my roles as reentry court mentor and peer minister, I have been able to successfully implement those tools. I now understand that every word that is spoken or not spoken has consequences, and they influence those that are around me. I have learned to give and to not take. I have learned to heal and not harm, and I have learned to speak up when something is wrong, no matter the circumstances. I understand that there are no words, there's no actions, and there is no amount of change that can erase the painful loss that I have caused my son, John Derrick, the Smith family, other generations that follow. And this guilt, regret, and shame will be with me for the rest of my life. Today, I humbly ask the board to please grant my petition of parole to continue my decades of growth and service outside of prison. Thank you.
Okay, thank you. Thank you for those words, and we'll get around to you and ask some questions in a little bit. We'd like to hear now from the warden. Would you tell us a little bit about her behavior and accomplishments and disciplines while she's been there?
Yes, sir. Ms. Thornton is one of our minimum security inmates. As she mentioned, she lives in one of our dorms mentoring. She has an excellent disciplinary record. Her last disciplinary write-up was in 2002. She's completed various programs, probably all of them. And she is an NOBTS graduate, which I know she's very proud of. And she does continue to mentor and offer peer support to the ladies that live here at LCIW. So like I said, we have zero issues with her. She's been a minimum security inmate for a long time. I know if she does get a favorable grant vote today, that she's working with the Parole Project for release plans and transition plans, which I know Mr. Blake will probably go into a little bit more detail on.
Okay. All right. Well, thank you for that. And we will, we'll go ahead now and talk to, let's go ahead before we get to the Parole Project and Miss Grable. Is that what I'm saying? Am I saying that right?
Miss Grodell.
Grobel. Okay, Miss Grobel. Okay, I'll probably say it wrong in just a minute again, so I apologize. It's not intentional. We'll save you to last and let you wrap up at the end of the supporters. And so let's go ahead and talk to the DOC chaplain, Miss Deborah Sharkey. Is Miss Sharkey there? Oh, there you are. Okay. Yes, ma'am. Would you go ahead and tell us what you have to say then?
Yes, thank you. Can I stand here?
Yes, ma'am.
Well, good morning, and thank you for the opportunity to speak on behalf of Ms. Brenda Thornton. My name is Dr. Deborah Sharkey. I serve as the Director of Chaplaincy Services for the Louisiana Department of Public Safety and Corrections, and I also direct the NOBTS Seminary Extension Center at the Louisiana Correctional Institute for Women. Because of that role, I still return to LCIW regularly and stay closely connected to our peer ministers there. Before working at headquarters, I served as the chaplain at LCIW for more than 11 years. In total, I have known Brenda Thornton for over 15 years. When I first met Brenda, she was a student in our seminary program. She shared with me on numerous occasions that when she first entered prison, she was insecure, frightened, and selfish. But that is not the woman that I encountered. From the beginning, I saw someone who was quiet, patient, respectful, and steadily developing into a strong and confident leader. As a student, Brenda excelled academically and stood at the top of her class. I often watched her tutor and encourage women who struggled academically. She was never required to do that. She chose to do it because she genuinely cares about others and their success. After receiving her bachelor's degree, Brenda stepped up into key leadership roles. She became a peer minister, a reentry court mentor, and a trauma healing facilitator. In her role as a peer minister, Brenda conducts dorm rounds, performs memorial services, graveside services. Like the warden said, she has minimum custody status, so it's very few people that are able to go to the graveside to perform those services as inmates. And Brenda also facilitates CTRP classes. She does lay counseling and grief counseling. She strictly follows institutional policies and chapel procedures, particularly with confidentiality. Brenda consistently goes above and beyond what is required. She notices needs and takes initiative. She has excellent people skills and she is calm under stress, patient in conflict, and often serves as a peacemaker. Another role that Brenda served in was to go and to be an orderly when some of our women were incarcerated at LSP. That was a very trusted position as well, and one that was very difficult. And Brenda volunteered to do that. So I've watched Brenda help people in difficult moments. And after the flood, when Brenda was incarcerated at Hunt with some of our women, she stepped up and became the chapel liaison and the chapel support for every one of our programs, faith-based programs that was at Hunt. And again, she gave up a lot of nights of sleep and sacrificed a lot, was not paid to do that. And that was something that she volunteered to do because she felt a call to serve Christ by serving others. But even before Brenda became a peer minister, she faithfully served for many years in the chapel vestry, preparing for our services across multiple faith traditions, Catholic, Protestant, Episcopal, and Jewish. She coordinated our chapel events, both religious and non-religious. Because I continue to oversee the Seminary Extension Center at LTIW, I still see Brenda regularly. I've watched her continued growth, maturity, and stability. The woman she is today has been shaped by years of consistent, faithful service and personal transformation. In all the years I've known her, Brenda has demonstrated integrity, accountability, compassion, and leadership. And I thank you again for the opportunity to speak on her behalf today. Honored to do so.
Okay, thank you, Ms. Sharkey, for those words. We'll take them into consideration. Mr. Randy Clement.
Yep, not Clement. My name is Randy Clement. I'm a permanent deacon in the Catholic Church, and I was a volunteer chaplain at LCIW for many years. I am here to support Ms. Thornton's request for parole. This lady, Brenda, that I can see on the screen back of me, has been more of a minister to me than I was a minister to her. I have lost multiple family members in gun violence, including my uncle, a priest, my niece, and my nephew, a sheriff deputy, who was killed in a drug bust that went awry. I was upset and didn't even want to go back to the prison, knowing that I may go and help people that killed my uncle. But I went. And Brenda actually supported me and loved me through my anger times and showed me that there's another side of life. She helped me on my journey for forgiveness, where I got to meet the young man in the prison serving time for killing my nephew. I can truly say that I am a better person knowing her. I didn't know her at the time of this incident, all those years ago. I didn't even know she existed. I had never heard her story. But now I have had the pleasure of knowing her but the 25 years that I've been working at LCIW. And I can truly say that this woman will better serve our society if granted a parole, so that she can serve people in the public as she did with me and those in prison now. I'm kind of selfish though. I hate to see her leave LCI because she's such a valuable part of my life. She's been like a family to me. But in my opinion, it would be a huge loss to society for her to have to remain in prison. She is not the person she once was. I am here today to guarantee this board that Mrs. Thornton has gone to be a remarkable lady and has helped us, a lot of us, including myself. I'm confident we will only continue to pour herself into helping others if she is granted release. Thanks for listening to me, and I'm honored to be to talk about it.
Thank you, sir. Thank you for those words, and we appreciate and we'll take those into consideration. Next, we'll go to Mr. Channing Blake with Louisiana Parole Project. Mr. Blake, would you tell us what you got on your mind?
Yes, sir. Good morning to this honorable board. Channing Blake with Louisiana Parole Project on behalf of Ms. Brenda Thornton. Because of the programming and the classes she's taken, she's been 20 plus years right up free. Her trustee status and her time served, we've accepted her into our program. We're going to offer her reentry services that include transitional housing, social norms, consumer skills, and many more. She will also be given a reentry specialist that'll mentor her through the reentry process. So based upon her record and rehabilitation, we ask that you grant her parole today. Thank you so much.
Okay, thank you, Mr. Blake. Appreciate that. And now we'll move on to Ms. Hannah, Ms. Grobel. Yeah, I don't know if I say that right.
We're gonna get there. My name's Hannah Rose. You can call me Hannah Rose. That might be easier.
Yes, ma'am. That might be me.
I'm Hannah Rose.
Thank you, ma'am. Tell us what's on your mind, please.
Yes, first I want to start by expressing our deepest condolences to the family of Johnny Thornton. Their loss is immeasurable, and the pain that they have had to carry both over the last 38 years and in returning here today is profound. We honor their suffering, and we recognize the impact of this tragedy on everyone who loved Johnny. The fearful 24-year-old Brenda Thornton at the time of this senseless murder is not the same wise 63-year-old woman before you today. Ms. Thornton now fully understands her role and responsibility and has spoken openly about her failures on the day Johnny died and her failures in the days and years surrounding it. What she did not share, out of humility and respect for the gravity of this hearing, is that she had been abused all her life until meeting Johnny. Her lived experience taught her that submission and silence were necessary for survival, and I do not offer this to excuse or justify her actions, but to provide context for understanding who young Brenda was all those years ago and how fear, trauma, and learned helplessness shaped her poor decision-making. While she neither committed an act of physical violence nor asked Dennis Moss to do so, Ms. Thornton has always felt deeply responsible for Johnny's death. She cooperated with law enforcement and accepted a plea agreement because she understood her failures and her choices contributed to his murder. Since that time, Ms. Thornton has spent nearly 38 years in prison, demonstrating an unwavering commitment to growth and service. For more than 3 decades, she has served as a Class A trustee, maintaining an exemplary disciplinary record without a single write-up in almost 25 years, reflecting far more than institutional compliance. This reflects genuine transformation. Ms. Thornton has become one of the most trusted and relied upon mentors within the institution. She teaches courses like trauma healing and thinking for a change, programs that are centered on emotional regulation, accountability, and healing. She also teaches good time classes, including Life of a Single Mom and the Onesimus Project. Since her last hearing, she's taken Sisters Keeper on domestic violence and Celebrate Recovery to continue her rehabilitation. As a reentry court mentor, peer minister, and lay counselor for the entire compound, she is entrusted with preparing other women for release, guiding them through crises, and modeling the self-discipline and morality needed for success. The institution depends on her to uphold the highest standard of conduct and to help others cultivate those same standards. Now, Ms. Thornton is a woman who knows and does better and is relied upon by the department to steer others in the right direction. Stephanie King, one of Ms. Thornton's supporters, who has successfully transitioned home from LCIW and now works in the Baton Rouge Public Defender's Office, wrote in her letter, "Brenda Thornton cares deeply about people and has no problem putting others before herself. When I first arrived at LCIW, she supported me and helped me navigate difficult times. I grew so close to her, I often called her mom." I am here to assure this board that Ms. Thornton presents no threat to public safety. She has long since aged out of any risk of reoffending. She has become a model of stability, integrity, and service. When this board recommended her for clemency in 2018, the warden remarked, "She is just focused on always helping others." And while no amount of rehabilitation can undo the harm of her past, the Brenda Thornton of today is prepared to re-enter society, not as the passive and immature young woman she once was, but as the humble, spiritually grounded elder, teacher, mentor, and servant she has spent decades becoming. We want to thank you for your time, your attention, and your thoughtful consideration of Ms. Thornton's request to complete the remainder of her sentence on parole.
Yes, ma'am. Thank you for those words, and we'll take them into consideration also for purposes of the record and so that Miss Brenda Thornton will know who all is here. Those that are here at headquarters but not speaking are Stephanie King, Beatrice Taylor, Susan Brown, Sabrina Monaco, probably wrong. Monaco, and Jan Waters. They are here in support, but not speaking, just so you will know that. We'll move on now to folks that are on Zoom, and this is those in opposition of this request. And we've got Brenda Renee Smith, John Smith, and Kimberly Hatton. So we'll first go to the victim's sister, Miss Brenda Smith. Miss Smith, are you on Zoom with us?
Yes, I'm on Zoom. Do you hear me?
Yes, we can.
Okay. I am in opposition. There is only half-truths that are told here today. And for that reason, I am in total opposition. For what she told, she made it sound like that Dennis Moss was totally in fault and she was only playing along but she totally planned out the murder of Johnny Thornton. She took out a large life insurance policy on him, and they planned his murder together. So she is totally at fault. And she did not tell that portion of the story. And I do not feel that she should be released. And she had a decision she could have made, and it come to that crossroad. And my brother is no longer here with us, and he cannot stand up for himself, so I am standing up for him. And I am totally against it and will always be against her release. And if my words have any bearing here today, I ask you, please do not release her and let the official court decision stand as it was on the day of the hearing back in 1988. as Judge Strong ruled in that decision.
Okay, thank you, ma'am. Thank you for those words, and we'll take those into consideration also. Let's move to those that are with Ms. Smith. Kimberly Hatton, if I'm saying that right.
You are.
Okay.
Thank
would
you for
tell
allowing,
us-
thank you for allowing me to speak.
Yes, ma'am.
And I can't even fathom her wanting to get out. She held her 3-year-old on her hip. She watched. She had time. She knew Dennis Moss stopped in Faraday, Louisiana and bought the ball bat, the machete, whatever. This was planned. She's up there telling lies. Brenda, come clean. If you have done all of these deeds down there, that's where you need to be, because you're not telling these people the truth. You are not, God knows what
Pat?
you did. Yes.
Speak to the board, please, ma'am.
Yes.
Speak to
Can
the
you hear?
board and not her.
Oh, I'm sorry. Okay.
Yes, ma'am.
Brenda planned it. She took out this big life insurance policy. She knew Dennis was going to stop and buy the ball bat, the machete. She stood there and watched them hit him over the head with it, stab him. She sat there and watched them drag him to his own truck and haul him off, and he was still alive when he was found. She then dug up the blood off of the ground and put it in a flower pot and covered the flower pot up with dirt to look like she planted flowers. She had all of this planned for money. And for Dennis Moss, for her boyfriend. Johnny had to drag himself, slide his feet to even go out there. And she told Dennis Moss that Johnny was trying to sell his welding truck or his whatever. She told him when to come and what to ask for. He was fixing to have back surgery. He slid his feet out to get out there to show him what he had for sale, and that's when they killed him. They stabbed him and hit him over the head with a ball bat. And she's going to sit down there and say that she didn't know. I mean, I cannot even imagine. She's lying to God. God knows what she did. Why would she want to uproot this child's life now? After he's gone on with his life, he's got a precious baby. He's got a precious wife. And why would you even want to come put that on him? He's gone on. Let him live his life. Don't come back and don't tell somebody that you will not try to enter his life again, because yes, you will. You've planned all of this. I'm proud of what you've done down there. I mean, it sounds like you've done what is expected of you or what you should do, but stay there. That's where you need to be. You have got a good life, obviously, there. Stay there. Don't uproot this child. Don't bring him. Don't
Ms. Hatton,
don't mess up his life.
Ms. Hatton,
I'm
please.
sorry. I'm just.
Oh.
I'm sorry.
Yes, ma'am. We appreciate
Okay.
the comments, and we will keep consideration, take them also. Now, finally, on behalf of those in opposition, we'll talk to Mr. John Smith, who's the victim's son. Mr. Smith?
Sir, John Thornton Smith. I don't believe she needs to be released from prison. She just said everything to y'all. She knew exactly what was happening. She knew she had time to do something, to call the authorities, to stop it, but she didn't. She made that choice. And I was there the whole time. And, you know, I don't think she should be released from prison. I really think she should be there, still stay there.
Okay.
And,
Go ahead. I didn't mean to cut you off. Go ahead.
that's about all I got to say. I really don't think she needs to be released. That's how I feel. That's how I feel, sir. I don't think she needs to be released. She knew the whole thing.
Okay. All right. Thank you, Mr. Smith. We appreciate you coming on, and we'll take that into consideration also. I'm sorry to all three of you for your loss. I know you hurt a lot and continue to hurt. Okay, well, we'll move in now, Miss Brenda. We'll move in now to asking questions a little bit. And all three of us are very familiar with your case. We've read hundreds of pages of hearings and the trial and police reports and commutation of sentence. And it's up to me to ask the questions. Case was assigned to me. Your good time date is in 2036, correct? Is that the time?
Yes, sir, I believe so.
Okay, so you'll be released in July of 2036 if things go right because of the law. You pled guilty to first-degree murder and received a life sentence in 1988. Is that correct?
Yes, sir.
Okay, and then you came before not this board, but you came before the pardon board and asked them to commute your sentence to 99 years with immediate eligibility for parole. And that was signed by the governor in August of 2023. Is that correct?
Yes, sir.
Okay, and that's why we're here. We've heard the details of the crime, and I don't really need to go over a lot of that. It's apparent that, and correct me if I'm wrong, you knew exactly what was going to transpire and allowed it to transpire as planned. Is that correct?
Yes, sir.
Okay. I want you to know that all law enforcement and the victims, of course, you've heard the victim statements, but all law enforcement is very opposed for this particular effort of you to get your parole. I don't really have any other questions. I'm very familiar with the case and statements and victim opposition and from all of the chaplain testimony and parole project. So I don't really have any other questions.
I just got a couple, Mr. Prater.
Yes.
Brenda, where's your family? I mean, I see all these people here, but none of them say brother, sister, cousin, anything. I mean,
The majority of my family, Mr. Freeman, is deceased. They were older and in poor health. The few remaining people that I have, they are also in their upper 80s, late 70s and upper 80s, which is my mother's two sisters that are there. And one is out of state and the other one is in a dementia assisted living area.
did they ever come visit you? Were they on your visiting list at one time?
No, sir.
Okay. And tell me about this insurance policy. That one caught me off guard, and I was on your case before.
Yes,
So did you
sir.
purchase an insurance policy on him?
I did not take out the insurance policy. My husband took out the insurance policy, and there was no payments ever made on it.
Okay. That's the questions I had.
Did you encourage him to take it out?
No, sir. He did because he was going to be reassigned offshore. He worked offshore and he wanted his liability to increase in case something happened to him for his son and myself.
Okay, thank you.
Yes,
Thank
sir.
I'd like to go into executive session.
Okay, we have a motion to go into executive session. Do we have a second? Okay, got a motion and a second to go into executive session. Hearing no opposition, we'll be in executive session. The time is 10:02. We'll be gone into executive session in the back room for just a couple of minutes. It won't take long. Then we'll come right back and we will take a vote and then announce our decision. So we've got some matters to discuss.
Okay, folks, we are a little bit in the Wayback Machine here, so I'm just going to bump us forward past the executive session, and then we'll see how all of this ends, hopefully.
Where you're
There we
doing,
go.
and I respect everything that everybody's said about you. However, because of victim opposition, because of law enforcement opposition, because of the fact that you do have a good time date, and hopefully we'll see you before then, but because of the fact that you pled and the family of the deceased, all of them thought that you were going to be in for life and then 99 years and now this. My vote is to deny your request. Mr. Freeman?
Okay, my vote would be to grant to the parole project for a minimum of 1 year and that you not go back to the parish where this crime was committed. No contact with the victims or your son unless initiated by them. That's my vote.
I concur with Mr. Freeman.
Okay, I'm sorry to tell you, but the vote is 2-1. And I hope that you will take every advantage of applying again. But I think that at this particular time, you're doing a great job where you are. They can use you as a staff member. You're like an unpaid staff member, basically. And keep doing the same job that you're doing, and you'll be blessed beyond, and you'll bless other people. But this time, as I said before, your parole is denied. The time is 10:11 in the hearing.